Good evening. We're now 14 days until the general strike. It is October 1st, and on October 15th is the general strike against Congress, against the duopoly, against politics as usual. It's an opportunity for people to say enough is enough. We will boldly challenge the status quo. Well, to start all these sessions off, we'll like to hearken back to the people who boldly challenged the status quo 235 years ago. The framers of the Constitution gave us a mission statement for the United States that's in the preamble. And so I'd like to recite the 52 words of the preamble and invite you to join me. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. Now, these are the preamble outlines the 5 duties of all Americans, and the legislative package that we're demanding Congress pass, the Blueprint for a Better America, is laid out to reflect those 5 duties. And we are working our way through Title I, which is establish justice. Now, there are a lot of reforms needed in our criminal justice system. And so the dozens of reforms in the legislative package generally break out into 3 categories: prison reforms, prosecutorial reforms, and police reforms. And tonight we're working through the Mathew Charles Prison Reform Act, the section that deals with a lot of the prison reforms. And you know, when we have 2 million Americans who wake up behind bars every single day, it's clear that something has gone wrong with our judicial system. And while it's definitely important to fix the problems that led to this rise in mass incarceration, it's also just as important to recognize the humanity of those men and women who wake up behind bars every single day. And so the reforms in this section do a couple of things that will rein in some of the worst abuses like solitary confinement, and will help people develop the tools to be better reintegrated with society when they come out. So we'll talk a little bit more about in the findings as we go along. I also want to say a couple of these demands come from the 2018 prison strike, where incarcerated people across the country came together with a set of demands and said, look, something's got to change. Right now, there's a prison strike going on in Alabama. And the way that one of the only tools that incarcerated people have many times is our hunger strikes. And so the Fast for Peace on October 15th is an opportunity for not just people who can vote to stand up and say, look, we demand change, but also an opportunity for incarcerated people behind bars to abstain from food for 24 hours and add their moral force to this call to Congress, this demand that we end poverty, end mass incarceration, and end the endless wars. We have the ability to do these things. And if we refuse to act, if we're okay with the status quo of tens of millions of people living in poverty and millions incarcerated while spending nearly $1 trillion on the military-industrial complex, what kind of people are we? What does that say about us? We can do better, and the Blueprint for a Better America is a big step in the right direction. Once again, this is a federal legislative package, so it only applies to the Federal Bureau of Prisons, and they have more than 134,000 people under their control. That is more than any individual state, but in a nation of 50 states, they're still just they're not a majority of That's not a majority of people nationwide. But change can start at the top and work its way down. And in a couple of these cases, we can use the power of the purse, the Byrne grant program, to incentivize states to adopt these reforms. You might remember when we talked about that, the Byrne grant program back in section 122, how the solitary confinement reforms were would be predicated on getting the Byrne grants would be predicated on adopting these solitary confinement reforms. So, but let's start at the beginning. Let's start at section 163, which I'm not even going to bother sharing my screen because it is just one single sentence saying that subchapter 1 of chapter 121 of Title 34 United States Code is repealed. These, let me try that again. Section 163 is just a single sentence. It says chapter 1997E of Title 42 United States Code is repealed, and that is the Prison Litigation Reform Act. So back in the 1994 midterm elections, the Republicans had a contract with America, and it contained a proposal to restrict incarcerated people's access to the judicial system. And President Bill Clinton, he signed the Prison Litigation Reform Act into law and made it more difficult for incarcerated people to file civil rights cases, to seek legal protections. And this reform led to a sharp increase in dismissed prison lawsuits, including those related to misconduct and unconstitutional conditions. Incarcerated plaintiffs were forced to fully exhaust all internal grievance processes within the prison before bringing their case to court. And you can imagine that when you're, as an incarcerated person, that trying to work within the system, within the prison, trying to persuade perhaps the warden of the prison that their guards have done something wrong can be an uphill battle. But there could be no outside access to the judicial system outside of that internal system until all the procedures were exhausted. The law also put limits on what courts could do. It limited the court's ability to grant relief. So even when a plaintiff succeeded, the court's orders to improve prison conditions were difficult to enforce, and they often ended prematurely. There was a specific requirement that court injunctions would have to have a finding that the relief was the narrowest possible. We don't want to give people any extra civil liberties than the absolute minimum that we have to. And so at the time that this passed, most states were under some form of court supervision. And so much of that just got swept away because all those decrees and things that had been entered into in good faith didn't have that finding that was now required by law. And so they all went away. Prison Legal News, who's a great source for news related to prison legal situations, they wrote about this, and they said, not surprisingly, prison and jail conditions did not improve with the termination of judicial relief. A couple other things the Prison Litigation Reform Act does. It says you can't file a lawsuit for mental or emotional injury unless you can also show a physical injury. And so, again, these are restrictions on access to the judicial system that we're putting on some Americans, but not all of them. Let's see. So Section 163 is going to repeal that. People who are incarcerated should maintain certain basic freedoms, including the ability to seek relief from unconstitutional suffering. And this was one of the demands of the 2018 prison strike. It is an essential part of establishing justice Again, how can you establish justice when you create two tiers and you give some people easier access than the other? And I know what you're thinking. Yes, we do that in a lot of ways. Those who have money have greater access to justice. But this is a place in the United States Code where we have codified it and we have statutorily restricted some people's access. And so this can be changed. One more quote from Prison Legal News. As soon as the PLRA was enacted, prison advocates challenged most of its provisions as unconstitutional and lost across the board. The Prison Litigation Reform Act will stay as it is unless Congress changes it. So, once again, the solution is passing federal legislation that will fix this. Okay, that concludes section 163. 164 is another demand from the 2018 prison strike. This is restoring access to the Pell Grant program. Also, back in 1994, you'll probably notice a theme of a lot of the get tough on crime of the 1990s had a lot of ramifications in our judicial system. But back in 1994, Congress blocked incarcerated students from accessing Pell Grants for higher education. Now, there were 23,000 people who were affected. So 1/5 of 1% of recipients, a very small number. And it really demonstrates the capriciousness of Congress's action, that here's some people who are trying to improve themselves. Nope, we're going to yank this away from you. You know, higher education is linked to improved chances of finding stable housing, long-term employment, establishing family stability. Studies have shown that access to post-secondary education in prisons or jails can reduce recidivism by up to half and save up to $365 million in state spending on detention. Like, these are good outcomes to encourage people to improve themselves. Again, incarceration, it should be a path to rehabilitation. And so this section would repeal the part of the United States Code that bars incarcerated people from accessing the Pell Grant program. Now, Congress has, in fact, made progress on this. In 2020, they passed the Free Application for Federal Student Aid Simplification Act. And in that act, it also did restore incarcerated students' eligibility for Pell Grants. However, those changes in the law aren't scheduled to go into effect until July 2023. And it doesn't fully repeal the ban. It just creates new bureaucracy and a loophole. So the blueprint for a better America likes to take a simpler way. Let's just repeal the language that created the problem in the first place instead of piling more stuff on top of it. And so it is just a straightforward deletion of that section. Yeah. So, okay. So that's pretty straightforward. Section 165, repealing incarceration incentive grants. This is another demand of the 2018 prison strike. And according to the Bureau of Justice Statistics, this is their explanation. To assure that offenders serve a large portion of their sentence, the U.S. Congress authorized funding for additional state prisons and jails through the Violent Crime Control and Law Enforcement Act of 1994. There's that year again, 1994. Within a year, Connecticut, Florida, Georgia, Kansas, Maine, Michigan, Mississippi, New York, North Dakota, Oregon, and Virginia all adopted these truth in sentencing laws. That act of Congress created an incentive for states to require that anyone anyone convicted of certain crimes serve at least 85% of their sentence. Now, as we go back in history, parole boards have had wide latitude to release people. So you might serve half of a sentence, or a third or 2/3, but parole boards had latitude. And so your sentence was sort of like the sentences that we see in the code itself. Your sentence was a maximum. And then so you had an incentive to try and be on your good behavior, to get along, to improve yourself, to demonstrate readiness for reentry in order to be paroled and be released from incarceration. But the United States, in the federal prison system, they ended the parole process back in the 80s. I want to say 1986, if I remember correctly. And with this legislation, this truth in sentencing law, they also encourage states to radically restrict the discretion of parole boards, in the same way that mandatory minimums remove the discretion of judges to judge. These truth in sentencing laws remove the discretion of parole boards to grant parole. So this, again, is just one small section of the law that is being repealed. As best I can tell, they're not actually issuing these grants anymore, but we can still strike it from the United States Code. There is one section that may still be relevant, not 100% sure, and that's section 12.113 of Title 34. And it's a law that reduces the amount of grants that a state can get if a person who had been incarcerated in that state for murder or sexual offense, if they are convicted in another state for a similar crime, the federal government will reduce the grants to the first state unless that person served at least 85% of their sentence. And so that was an extra incentive for states to adopt these sort of policies. And so we can wipe those off the books in our effort to establish justice. Let judges judge, let parole boards grant parole, and let us see the value in every human being. Let us see everyone's ability for self-improvement, for rehabilitation, to be better. You know, America as a country, we have made mistakes. We are not perfect. And all those incarcerated people, all the unincarcerated people, we are all imperfect as well. But we can always be better. And as we go along, we'll talk more about ways to, well, anyways, all right. That concludes section 165. All right, moving on to section 166, identification for people leaving incarceration. And this is essentially Senator Cory Booker's New Pathways Act of 2019, which does pretty much what the title says, and asks the question, you know, how do we, after someone is released, how do we help them get back up to speed? How do we help them merge onto the highway of American society without putting unnecessary speed bumps and roadblocks in their way? And one of the biggest barriers to reacclimating into society can be a lack of identification documents. You know, if you need photo ID to do an awful lot of things in this country, whether it's, you know, maybe to find an apartment, or to open a bank account, to get a job, to do all these sorts of things. And so when an incarcerated person is released, then helping them have these documents in hand makes it that much easier for them to get back into a normal, productive life. So section 166, I'm going to share my screen, and we can take a look at this real quick. All right. You can see section 163, 64, 65 are all just some straight repeals. All right. Section 166. And so the Bureau of Prisons already has this duty to collect some of these documents. We had that it'd be done at no cost to the incarcerated person. And there's some definitions about directly released prisoner, somebody who's getting released directly and not in pre-released custody. And there are two tiers here for citizens and non-citizens. So if you are a non-citizen, then the help would be in confirming and obtaining that they are lawfully present and eligible for employment in the United States, and giving them, making sure that they have those documents. But for non-citizens, for regular citizens, includes other identification documents such as a social security card, a birth certificate, and certificate or a passport, or other documents that would establish where you were, the birth. So all those kind of things that they need. In addition, they would also ensure that for citizens, there would be stop this. For citizens, they would also ensure that the individual had a debit card for their U.S. Treasury account, which we'll talk more about in another week or so. That would allow them to draw their $300 a week as part of the American Union Jobs Program, as universal basic income. And so, again, the question is, what is justice? When we incarcerate someone, and if we let them out and still chain them, hold them back, restrict them, handicap them without access to money, identification documents, education, things like that, are we really encouraging people to go out and be their best selves? Are we setting them up for failure? And the answer, by our high recidivism rate, is that too frequently we're setting people up for failure. And if you talk to incarcerated people, you'll hear that all the time. And so here are a couple things we can do on the federal level to start to turn that process around, help people succeed, help people be better Americans. And okay, now before we get into the next prison reform, we've got section 167. Now, this was a late addition to the Blueprint for a Better America, because this came about as a result of the United States Supreme Court decision, Shin v. Ramirez, on May 23rd. And the injustice that it created needed to be addressed. And once again, the only way it could be addressed is through an act of Congress. And so addressing it here in the Blueprint for a Better America was the logical thing to do. So let me talk a little bit about this case. And Shin was the Attorney General of Arizona, I believe, and Ramirez was the plaintiff, the incarcerated person who brought the case. But there was another case that got rolled up with this, and that's the case of a man named Jones, who in 2018, a federal court had overturned his conviction. He was on death row. They overturned his conviction, concluding that he had failed to receive effective counsel. And so the Sixth Amendment of the Constitution says that that in all criminal prosecutions, the accused shall enjoy to have assistance of counsel in their defense. And Jones didn't get that. So the federal court, the federal judge ruled that if he had effective counsel, if he had introduced, anyway, if he had effective counsel, quote, there is a reasonable probability that his jury would not have convicted him of any of the crimes with which he was charged. However, after the Arizona's Attorney General, after they lost in the Ninth Circuit Court of Appeals, they appealed this decision. And during those oral arguments, state prosecutors kept saying that innocence wasn't enough. Innocence wasn't enough to throw out Jones' conclusion. So again, you've got to jump through these hoops in order to access justice. And if you miss a hoop, then it's too bad, so sad. I'm not buying it. Anyways, the Supreme Court was more persuaded, and on May 23rd, by a 6-3 vote, the Supreme Court concurred. And so Barry Jones's innocence was not enough to keep him off of death row, and the state of Arizona can kill him, even if there exists a preponderance of evidence that he committed no crime. Now, the specific thing that they were trying to do was to have an evidentiary hearing to say, look, we had bad counsel during the first time around, and then it was a court-appointed defender, and who was ineffective, and then to appeal, Jones once again got a court-appointed public defender who again provided ineffective counsel. And so now that those claims of ineffective counsel have been upheld, have been recognized, then the obvious thing to do is to establish justice, is to open the doors to presenting evidence that would demonstrate that would cause a reasonable person to conclude that he was innocent. However, that's not what the Supreme Court concluded, and the Supreme Court said that a federal court, quote, may not conduct an evidentiary hearing or otherwise consider evidence beyond the state court record based on the ineffective assistance of state post-conviction counsel. Now, on one hand, the Supreme Court is offering a very narrow but accurate view of the United States Code. And I'm just going to go ahead and, but on the other hand, it would have been very easy for the Supreme Court to say that under the Sixth Amendment of the Constitution, a criminal defendant has a constitutional right to counsel, and they haven't been given this right. They have been given ineffective counsel. And so in order to protect their Sixth Amendment constitutional right, the way to do that is to allow effective counsel to be effective and introduce evidence. That would have been a very straightforward and consistent with previous Supreme Court decisions if they had ruled in that way. They chose not to. They wanted to scrupulously follow the letter of the law. So I'm going to share my screen and we'll take a look at what exactly the letter of the law looks like. And so you can see section 167. This is the section of the law that is being amended. Oops. And so this is the text that says, if an applicant, the applicant has the burden of presenting clear and convincing evidence, and if an applicant hasn't developed the factual basis of this claim, the court shall not hold an evidentiary hearing on the claim unless, and here's where the Supreme Court says, unless the claim relies on either one, a new rule of constitutional law made retroactive in cases, or on collateral review by the Supreme Court that was previously unavailable. So if the rules change, then okay, then you get a chance for a review. Or two, a factual predicate that could not have been previously discovered through the exercise of due diligence. And once again, okay, if you've been harmed in these ways, then you get the opportunity to be made whole when you would have been unable to present an adequate the evidence necessary at the time. And the Supreme Court said, look, Congress was very specific. Congress is the legislative branch of the United States. These are the two loopholes they left. And ineffective counsel is not on the list. So too bad. So sad. If Jones is innocent, well, the important thing is that there is finality to this case. And so if we execute an innocent man, at least it'll be over and done, and we can move on to something else. So the way that we fix this is by adding a Roman 3, a finding of ineffective counsel would be grounds for a new evidentiary hearing. And that's what that would do. And it's a straightforward fix. In the case of Jones, horrible crime, and a little 4-year-old girl was died. And the basis for his conviction was that they said that he had abused her, and the next day she died of an infection. And as most people can tell you, infections don't kill you in one day. But Jones's counsel didn't bring any of this evidence, didn't bring anyone to question this to the stand. And so he was convicted and sentenced to death. And the Supreme Court has said he's not allowed to introduce any new evidence. We can fix that. We can change the law. We can establish justice by forcing Congress to act, by joining the general strike on October 15th and saying, look, we're supposed to pride ourselves on being a nation of liberty and justice for all, not a nation of what? A nation of finality in our justice system? That's not really an inspiring thing. Speaking of not inspiring things, now let's talk about solitary confinement. I'd like to just go ahead and read the findings from section 171 into the record. The Congress finds the following. The United Nations Office on Drugs and Crime has issued the Nelson Mandela Rules, the United Nations standard minimum rules for the treatment of prisoners. And the use of indefinite or prolonged solitary confinement for more than 15 days is defined as a form of torture. Rules 43 to 45 define restrictions for solitary confinement. In the summer of 2019, the United States had more than 55,000 incarcerated people who had been in solitary confinement for 15 days or longer, including thousands for more than 3 years. A 2014 study published by the American Journal of Public Health found that, quote, self-harm is strongly linked to being in solitary confinement. Inmates punished by solitary confinement were approximately 6.9 times as likely to commit acts of self-harm. A Department of Justice review of solitary confinement published in January 2016. It summarized their conclusions by emphasizing, quote, as a matter of policy, we believe strongly this practice should be used rarely, applied fairly, and subjected to reasonable constraints. The purpose of this part is to reduce the use of solitary confinement, recognizing the redeemability of every human being and improving America's moral standing in the world. There's a couple of books about solitary confinement I'd recommend reading. One is called Hell is a Very Small Place. It has history and writings by those who have experienced solitary confinement. And this is not new. Back in 1842, Charles Dickens, he was doing like a United States book tour, and he visited the Eastern State Penitentiary, and he saw people being held in solitary confinement there, and called Americans out on it and said, "Look, this is not right." In 1890, the U.S. Supreme Court found that solitary confinement caused harm to people's mental health. This is a Supreme Court decision, the case In re Medley. Some prisoners, they found, quote, became violently insane. Others still committed suicide, while those who stood the ordeal better were not generally reformed, and in most cases did not recover sufficient mental activity to be of any subsequent service to the community. When we incarcerate people in a small 6x9 cell for weeks, months, years, even decades at a time, we are intentionally inflicting suffering on people, unnecessary suffering, and that is not justice. We can do better. Recently, a man named Albert Woodfox passed away. He wrote a book about his 4 decades in solitary confinement in a Louisiana prison. Finally, his wrongful conviction was overturned and he was released a few years ago, and passed away in his 70s. He'd spent more than half of his life, 4 decades, in solitary confinement. Other examples include Caleb Browder, who was a teenage boy that was accused of stealing a backpack. And so he was held in New York on Rikers Island for 3 years because his family couldn't pay his bail to get him out. He spent 2 of those years in solitary confinement. And it took such a toll on his mental health that after eventually the charges were dropped and he was released, that he committed suicide. And there are so many cases of, so many examples of the harm that solitary confinement does. And so Section 172 would reform the way that the United States works, the way that the United States does solitary confinement, and bring us up to this global standards, these Mandela rules of no more than 15 consecutive days in solitary confinement. And this was a tough section to write. We looked at a lot of different pieces of legislation. There's no good model federal legislation. So we looked at a lot of different states. We looked at best practices and standards and put them together into this one package in this one section. And I guess I want to say again that it's easy for candidates to, on the campaign trail, to say, I support reforming solitary confinement, but it's much harder to actually follow through, because what exactly does that mean? And so the Blueprint for a Better America is a better model than what candidates traditionally do, where they make vague, nebulous promises, because we can spell out exactly what that means. What does reforming solitary confinement look like? Now, some of the progress that has been made in the last decade was by President Obama, who restricted the use of solitary confinement against juveniles in 2016. He wrote an op-ed in the Washington Post, and he wrote, quote, "The United States is a nation of second chances, but the experience of solitary confinement too often undercuts that second chance. Those who do make it out often have trouble holding down jobs, reuniting with family, and becoming productive members of society. Imagine having served your time and then being unable to hand change over to a customer, or to look your wife in the eye, or to hug your children." These are some of the stories that you'd read in that book, Hell is a Very Small Place, of spending these long periods of time where all the humans that you interact with are only in one direction, and then being out in the real world where people are all around you. And it can be a very disconcerting experience that creates a lot of extra stress for someone who's already been going through the stress of transitioning from incarceration to general society. Let's see. So there is some progress on the state level. Some states like Colorado, New York, Connecticut, and New Jersey have limited this practice for youth or adults. California this week had the legislature passed a bill that would have restricted the use of solitary confinement in California. Unfortunately, the governor vetoed it because California is one of the worst offenders when it comes to the use of solitary confinement, many times incarcerating people not based on their crimes, but keeping them in solitary confinement based on accusations of gang affiliation, and not something that somebody can appeal or challenge. It's just something to be endured. So before we go through this, I'll just talk a little bit more about what it does. It reforms the use of solitary confinement, brings us up to the timeframes of the Nelson Mandela rules. It ensures that before a person is sentenced to the prison within a prison, that they have legal counsel, just like they would for any other criminal proceeding that would get them incarcerated. Puts restrictions on vulnerable people who can be sent there. So anyone with a serious mental illness. Not surprising, as we've heard, solitary confinement does not help that. Any other mental impairments, anyone under the age of 21 could not be sentenced to solitary confinement. And just as importantly, daily clinical evaluations would be required. So a clinician would check in with a person each day that they were confined in solitary confinement to check in on their mental health and see how they're doing. Yeah, okay. Let me go ahead and share my screen and we will go through this section of the legislation. All right, purpose. Okay. So we create a new chapter of the United States Code that has, I don't remember, 4 or 5 different subparts. And subpart A is the definitions. Define clinician. A correctional facility is any facility detaining people as part of a government service or contract with a federal agency. Define developmental disability. Emergency confinement. There are exceptions to these restrictions on solitary confinement that include emergency confinement, and that means placing them for no more than 24 hours when there is reasonable cause to believe it is necessary for reducing a substantial risk of imminent serious harm to the inmate or others in the correctional facility, as evidenced by recent threats or conduct. So without due process, you could still put someone in solitary confinement for up to 24 hours if it meets this definition of emergency confinement, which includes that a less restrictive intervention would be insufficient to reduce this risk. Inmate is anyone who's confined in a correctional facility. Medical seclusion is that same involuntary confinement, but under medical supervision. Medical staff. Psychiatric emergency means an acute disturbance of behavior, thought, or mood of a patient, which, if untreated, may lead to harm either to the individuals or others in the environment. Serious mental illness means a disability based on mental illness, a history of psychiatric hospitalization, or recently exhibited conduct included but not limited to serious self-mutilation, indicating the need for further observation or evaluation. So serious mental illness can, under the definition of serious mental illness, can be ongoing or diagnosed problems, but it can also immediate behaviors can trigger this definition as well. Solitary confinement means the involuntary confinement of an inmate to a cell or similarly confined holding area or living space for approximately 22 hours or more a day with severely restricted activity, movement, and social interaction. Solitary confinement does not include confinement due to a facility-wide or unit-wide lockdown that is required to ensure the safety of inmates and staff. So if there is a lockdown, as has happened, I don't know if it was earlier this year or last year, where the Bureau of Prisons locked down all their 122 prisons. In that scenario, these restrictions on solitary confinement don't apply. Because it's done as on a facility-wide or unit-wide basis. This definition, we again uses the definition from the Mandela rules of 22 hours. That is not a standard definition per se. Some states have adopted smaller numbers, but as a place to start, the international standard is certainly better than the status quo. And this definition of solitary confinement means involuntary confinement. So if a person asked to be restricted from the general population for whatever reason, that would not trigger that is not defined as solitary confinement. It's only the involuntary confinement. And then vulnerable persons, these are people who are 21 years of age or younger. Again, when the mind is developing, as it is until, it doesn't just stop developing at age 18, it continues. And these restrictive environments are even less helpful for healthy mental development. So 21 years or age or younger, serious mental illness, developmental disability, or has significant neurocognitive impairment from a condition such as dementia or traumatic brain injury. In those cases, they would not be able to be assigned to solitary confinement. Those who have serious medical conditions, which can't be effectively treated in solitary confinement, or someone who is pregnant or has given birth, suffered a miscarriage, or terminated a pregnancy in the previous 45 days, these people could be assigned to medical confinement, if appropriate, instead of solitary confinement. All right, subsection B is the restrictions on the use of solitary confinement. And 1, correctional facility shall not place any vulnerable person in solitary confinement except for the use of medical seclusion. And no other person shall be placed in solitary confinement except for disciplinary reasons or for temporary emergency confinement. So that's pretty straightforward. If you're going to put someone in solitary confinement, it can't be a vulnerable person. It can be either for temporary emergency confinement, or as a result of disciplinary reasons. And as we'll get to, there is a process in subsection C for how that would work. 2, no person can be placed in solitary confinement more than 15 consecutive days or 30 in a 60-day period. And any person placed in solitary shall receive a personal and comprehensive medical and mental health examination conducted by a clinician pursuant to subsection D. So again, mental health checks. No person placed in solitary confinement shall be subjected to corporal punishment, placed in a cell or holding or living space that is dark or constantly lit, or that lacks functioning sanitary facilities, proper ventilation, or temperature monitoring. C, denied access to appropriate medical care, including emergency medical care, or denied or given reduced access to food, water, adequate clothing, or any other basic necessity. No variation of food from the standard menu shall be permitted without the inmate's consent, except for a limited period not to exceed 7 days. For an inmate who has used food or food service equipment in a manner that is hazardous to the inmate or others. In developing this section, I talked with incarcerated people and who weighed in on some of the conditions that they had experienced in solitary confinement. And so these basic complaints of either the lights are off or the lights are always on, or food. Some states use something called Nutriloaf, which is basically a very bland brick of food that has all the necessary, it's beans and vegetables and cheese powder and just all sorts of things that that help somebody meet their basic needs, but with no seasoning. So it's very bland and tasteless. And the state of Vermont, I believe, has ruled that feeding it to inmates is cruel and unusual punishment. And so it's prohibited there. And in any case, that is sometimes used as a further punishment for people in solitary confinement. This legislation would prohibit variations in a person's food from the standard menu, unless they're by their request, they're vegetarian or eat kosher or whatever, but wouldn't allow for that except in limited cases for up to a week. So subsection B deals with how we treat someone in solitary confinement. Subsection C is the using solitary confinement for disciplinary use. So in order for someone to get sentenced to this jail within a jail, correctional facilities have to define how exactly that, what sort of behaviors or actions can get them, get a person sentenced to that. And if a person is accused of a violation or an offense that, let me highlight this. Solitary confinement shall be reserved for offenses involving violence or the threat of violence, coercion involving sexual acts, involving escape or posing a threat to institutional safety by encouraging others to engage in such misconduct. And so those are the things that someone could be sentenced to solitary for as a disciplinary action. When they do, generally you would need to convict them before sentencing them to solitary, but there's an exception if it is a serious offense and it would otherwise be appropriate. That decision to put someone immediately in solitary confinement would be reviewed by a high-level authority who is not involved in the initial placement decision. And they shall be given an initial hearing within 72 hours. Any inmate who demonstrates good behavior during the investigative solitary confinement should be considered for release while awaiting the disciplinary hearing. And absent compelling circumstances, such as a pending criminal investigation, an inmate should not remain in investigative solitary confinement for more than whatever the maximum term is that they could be sentenced to under whatever the most serious offense charged is. Disciplinary hearings set out some due process here. Make sure the inmate has the ability to appear, that they have access to legal representation. There's the Department of Justice has this Defender Services Program. That the hearing is conducted by an independent hearing officer outside the regular chain of command, that the hearing is recorded and that a transcript is made available, and that there is a written statement in writing of the reasons for the decision that is made. There's some basic protections there. When the disciplinary hearing officer is confronted with an inmate who demonstrates symptoms of mental illness, the officer shall refer the inmate to a member of the medical staff to provide input on what are the consequences to this person's mental health if we put them in a small room for days, weeks, or months and cut off their access to normal human interaction. And that the disciplinary officer hearings shall take the psychologist's findings into account when deciding what, if any, sanctions to impose. If the hearing results in an adjudication of guilt, that the hearing officer also has to conclude that other available sanctions are insufficient to serve the purposes of punishment. An inmate who's an vulnerable person, described in some subparagraphs E or F, that was the a pregnant person or someone with a medical condition could be placed into medical seclusion instead of solitary confinement. In general, anytime that someone spent in investigative solitary confinement would be credited towards their punishment, and sentences should generally be served concurrently. During the last 6 months of an inmate's term of correction, officials should avoid placing the inmate in solitary confinement. Again, as we're trying to help people get back on the road and merge back into society, we don't want to put any roadblocks or things in their way right before they're released. And so for the last 6 months, we want to help their mental health be as clear and functional as possible. So restricted in the last 180 days and targeted reentry programming if it was necessary. And as inmates who demonstrate good behavior during disciplinary solitary confinement shall be given consideration from early release from solitary confinement as well. So that's how someone could be convicted of a infraction and sentenced to the prison within a prison. Subsection D deals with medical and mental health examinations, requires that a clinician give a medical and mental examination before sending someone to solitary confinement, unless it's an emergency. If the evaluation determines that they are a vulnerable person, that they have this is causing issues with their mental health, they shall immediately be removed from solitary confinement. And a punishment of disciplinary solitary confinement would be satisfied by this. So it wouldn't be, we're going to wait till you feel better and then put you back in. That would be the end of that. E is medical seclusion, and medical seclusion is can be in response to a psychiatric emergency, and they would be under observation. Suicidal inmates' clothing may be removed only if an individual assessment finds such removal necessary, and that the affected inmate shall be provided with suicide-resistant garments that are sanitary, adequately modest, and appropriate for the temperature. Again, this is something that prisons often do, is to strip a person on suicide watch, and generally not. It's one of, if you remember, the conditions for solitary confinement also included ensuring adequate clothing as well. That removal of clothing is often done to humiliate people. So this would restrict that. So there's also an exception here for if it's necessary for an inmate with a readily transmissible contagious disease, that you can make accommodations to address those special needs. And that is the way that we can reform solitary. That is the way we can reform the practice of solitary confinement in the United States. And so we add that, we add this new section, the effective dates, not later than June 30th, 2023. So you've got 8 months or so to develop the rules, guidance, and regulations to implement it, and effective in 1 year. This section would be at the start of the 2024 fiscal year would go into effect. All right, seeing no questions in the chat. Let's say Colorado did this like 15 years ago, and tried to eliminate the use of solitary confinement as much as possible, and they saw huge reductions in assaults against staff. And again, if you treat a person like a human being, you're more likely to get that response in return. Once again, the golden rule of treat others the way that you would want to be treated applies to the way that we treat incarcerated people in this country. And we have so many of them. We can do better. And the Mathew Charles Prison Reform Act will go a long way in that direction. So we can end poverty, end mass incarceration, and end the endless wars if we can persuade Congress to put the blueprint on the president's desk before the midterm election in exchange for our votes. The American Union is a union of swing voters, and all the members of Congress who make this happen will get the American Union endorsement. And if they refuse, their challengers who support the blueprint will get the endorsement. As a union of swing voters, it just takes a small percentage to control the outcome and control the balance of power in Washington, D.C. We, the people, can do this. It's one set of solutions for all 470 federal races by coming together on October 15th and rejecting the status quo, the general strike against politics as usual. We can make it work better. We can come out of the pandemic as a nation reborn, one that gets back to our constitutional duties. First and foremost, establish justice. Thanks to everyone who tuned in tonight. We'll see you tomorrow. We'll talk more about the nonviolence that makes up the philosophical foundations for this legislative package and the American Union.